each of our other speakers, and then we'll open the forum up for questions and comments.
All right. Well, thank you. I'm happy to be here, and I think it's good that I go first. I'm eating into my first minute here by giving a bit of an overview on the scientific evidence for the effect of police on crime and some of the research and the problems in the research on racial profiling. And this way, when Heather MacDonald and Professor Rudovsky talk, I'll hopefully help provide some background detail. So one of the things I want to point out is there is existing literature out there that suggests that police strength matters. When we hire extra police and we put them to good use. In particular, studies that focus on putting extra police in high crime areas, or what's called hotspots, or quasi-experimental studies, for example, that look at what happens after terrorist events or concerns with terrorism when we put extra police in an area. It turns out that when extra police are deployed to an area, they can reduce the crime rate. Now, that may not surprise you, but there's a lot of skepticism until recently about that. Now we've got a good body of evidence. The best evidence suggests that when you put police, what we call place-based approaches, so when you put police in high crime areas for at least a short period of time, they can drive crime rates down. And there's something like 21 kind of good quality studies. About half of them are actual experiments. So that means there's a treatment and a control group that was randomized, which means that we can rule out other factors. And the other half are roughly or quasi-experiments, so they're not quite as good. And I'll just show you a quick plot of these. So you can see these are studies in different settings, from Philadelphia, a drug corner study, Kansas City gun study, all the way down to some studies, including in New York, that occurred in the past. The majority of studies are to the right of the graph, so that suggests the treatment, the extra police in the area, reduces crime relative to the control area. But you can see there's quite a bit of variation. We also know some research on police tactics. So in particular, the research suggests that when police are more aggressive about enforcement of nuisance crimes, you can see reductions in robbery rates, including a very important study by John MacDonald in 2002. That's a joke. But these studies are relying on basically measures of DUI or disorder arrests, and they're not experimental. They're looking at correlations over time, and so we can't rule out alternative factors. So then you raises the question, what about New York City? New York City's done hotspots policing, and it's also done a lot of aggressive or order maintenance policing. And there is some research that's pretty decent on New York by Rick Rosenfeld and colleagues, at least from the 1988 to 2001 period, that suggests in precincts where New York was more aggressive about making arrests for misdemeanor ordinance violations, that the robbery rates declined more significantly in those precincts. And they point out that these effects are pretty small, but they are statistically significant. So in the more recent era, we've seen this trend of increasing movement from arrests to stops. So movement from focusing on arrests to also focusing on stop, question, and frisk in New York. And you can see this trend of African Americans versus white stops has gone. The white stop rate has gone up some. The African American stop rate has really climbed. And at the same time, crime has gone down in New York City. So that may tell you that there's a correlation strong enough that we think that stops reduces crime. But if you look at a longer historical view, what you'll see is a lot of things are changing, not just in New York, but even in Los Angeles during this period of time. And the big crime drop in New York and LA both started in about 1993-94, which is true for the entire country. So New York has definitely seen major declines in crime, but it really started in the early 1990s, shortly following the Safe Streets Act, where New York hired a bunch of extra police officers, and then following on with CompStat. And then the more recent era, since 2002, has been the era of really focusing on hotspots policing and stop and frisk. All right, so what about these kinds of stops? Do we have good evidence for just making what we call Terry stops, which are stops, question, frisks based on suspicious behavior? And the answer is we really don't. We have one decent study from 1975 in San Diego that compared 3 different areas, and it found when you suspended field interrogations, which are the same thing, stop, frisk, crime rates went up by about 20%. But I point out 2 things. In San Diego, they only did about 4 field interrogations in a given day in a patrol area. So this is a very small dose compared to what we're seeing in New York. And it was a very short comparison time period, and it was 1975. Okay, so I'm going to run out of time. That's fine. There's 2 significant gaps in the literature. We know a little about the effect of increasing police over sustained periods of time. We know that if you put extra police in an area, you can reduce crime, but we don't know what that effect is over long periods of time. And we do not know if field interrogations actually reduce crime. Do you need to stop, question, frisk scores of people to reduce crime? And since I'm out of time, I was going to answer this question is, what do you know about the racial bias in Terry stops? But during Q&A, I'll be more than happy to discuss some of the limitations in the research on racial profile. All right.
Thank you very much, and thank you to Mr. Whitesell at the Federalist Society and to Penn for having me here. It's a great honor to be here again with Professor Rudovsky and now with Professor MacDonald, and to have Amy Wax moderating. It couldn't be a bigger brain trust. I'll briefly summarize what happened in August in New York City. Judge Shira Sheindlin declared that the NYPD had been willfully and deliberately engaging in racially biased policing, and she relied very heavily on the statistical work of a Columbia law professor, Jeffrey Fagan, his regression analysis that purported to show that race, not crime, was driving police activity. She used his work for both the 14th Amendment analysis, which claimed, according to Shiendlin, that the police were differentially applying their stop and frisk activity, and also she relied on Fagan for her 4th Amendment analysis, which concluded that the police were making stops without the adequate reasonable suspicion. Let me provide some context for New York City policing that was left completely out of Judge Shiendlin's opinion. None of this entered. This last Sunday at 5:10 p.m. in Bedford-Stuyvesant, a 49-year-old man was sitting in his car and he was shot dead. This Friday night, in an outburst of violence across the 5 boroughs at 5:50 p.m. In the public housing project in Flatlands, Brooklyn, a 26-year-old was shot dead in the lobby of his housing project. At 1 a.m. in the Bronx, a 17-year-old was shot dead in the courtyard of his housing project. At 1:30 a.m. in Springfield Gardens, Queens, a 30-year-old male from Newburgh, New York, was killed. At 2:30 a.m., 3 teens hanging out on the corner in Brownsville, Brooklyn, 2 of them female, were shot, though not lethally. And at 4:10 a.m., a man was shot outside of a strip club in Woodside, Queens. Last Tuesday, 2 24-year-old females were shot dead in a housing project in Lafayette Gardens in Brooklyn. 2 weekends before Judge Shira Sheindlin issued her opinion in August, 10-year-old Breonna Palmer was shot in the torso in Far Rockaway, Queens. And 2 days before closing arguments in Floyd versus New York on May 18th, 14-year-old Daja Robinson was shot dead in a bus in South Jamaica, Queens, coming home from a friend's birthday party. The gunman had sprayed bullets virtually randomly at the bus, trying to shoot somebody else inside of it. Previous summer was characterized by basketball court shootings. There was a 4-year-old boy in the Bronx who was shot dead at a basketball court, and a 25-year-old member of the Harlem Youth Marines was shot dead in central Harlem. Now, virtually all of these shootings are happening in minority neighborhoods, Virtually all of their victims and all of their perpetrators are black. The racial disparities in crime and victimization in New York are stark, as they are in every other city in this country, Philadelphia included. Blacks commit 80% of all shootings, though they're 23% of the population. Blacks and Hispanics commit 98% of all shootings in New York City. Whites commit just over 1% of all shootings, though they're about 35% of the population. The per capita shooting rate in Brownsville, Brooklyn, which is a predominantly black neighborhood, is 81 times higher than in Bay Ridge, Brooklyn, which is a few miles away and is predominantly white and Asian. 81 times higher chance of getting shot in Brownsville, Brooklyn. This data comes from the victims of and witnesses to crime reporting to the police. Again, none of this crime data ended up in Shiendlin's opinion. The police cannot respond to these crime patterns without producing racially disproportionate law enforcement activity, whether it's arrests or stops. Each shooting, each robbery is going to produce an intense police response. Police are going to flood the area. These are usually gang activities. They're going to be looking for signs of gangs, people with gang insignia hanging out on corners, looking to make a retaliatory shooting. They're going to be asking questions. They'll probably be using their trespass power to make trespass stops, trying to interrupt another life being taken. Why are they there? In order to save lives and to try and give the law-abiding residents of poor neighborhoods the same freedom from fear as people in affluent neighborhoods take for granted. So crime data is one main driver of police enforcement activity. Does not show up adequately in statistical analysis I'll discuss, but the other main driver that does not show up at all in the types of analyses that Jeff Fagan does is community requests for police response. Last fall, I spoke to an elderly cancer amputee in the Mount Hope section of South Bronx. She's terrified to come into her lobby to pick up her mail because of the trespassing youth that are hanging out there smoking marijuana. She told me, as long as you see the police, everything's A-okay. She only comes down after the police have been there conducting trespass patrols. She longs for the time several summers ago where the police had established a watchtower on the corner of her street because there were so many shootings at night from gangs. She said, I wish we get our police back. Please, Jesus, send them back. Go to any police community meeting in the South Bronx, in Brooklyn, and Central Harlem. This is what you're going to hear. We want the dealers off the streets. We want our quality of life. You arrest them and they're back the next day. This March in the 41st Precinct in the Mott Haven section of the South Bronx, I heard people complain about, I smell marijuana in the hallways. There's a stench of smoking. I want that out. There's a nightclub outside where I try to sleep. They're out there all night smoking marijuana and making noise. Please take care of this. The police cannot respond to these heartfelt requests for public order and safety without generating racially disproportionate stop data, because these requests come overwhelmingly from those neighborhoods that have open air drug markets and where people are being most victimized. Now, these drivers are not captured in the models that Jeffrey Fagan and others have used to try and test for police activity. Again, no effort to include community requests, but even their crime, the way Jeff Fagan and others have modeled crime, is inadequate. For example, Fagan treats gang homicides and domestic homicides identically. So he'll feed into his model, okay, we've got crime, but homicide, it's all the same. So if you have a domestic homicide, and the vast majority of homicides committed by whites and Asians in New York are domestic homicides, he will expect the same police activity in a neighborhood that has just had a domestic homicide as he would in a neighborhood that has had a gang homicide. But obviously, domestic homicide indoors is not a street crime. It's not going to produce the same police activity looking for gang activity and trying to prevent a retaliatory shooting as when a spouse has just been killed by his or her spouse. Fagan also lagged crime data by 1 month so that, 5 minutes left, so that he treated last month's crime data as the relevant factor in determining this month's police stop activity by an entire month. In New York City, thanks to the revolution known as Comstat policing, the police are using crime data collected from the previous day or the previous roll call. Cops are going out working with up-to-minute policing. This was the mantra of Jack Maple, the architect of New York City's policing revolution, up-to-the-minute crime. They're not going off of last month's crime data. So if there was a shooting yesterday in the Mott Haven section of the Bronx that produces a flood of officers trying to prevent a retaliatory shooting, but there wasn't a gang shooting last month, according to Jeff Reagan, there should have been no police activity. There was no reason to have stop activity in Mott Haven this month. This is completely flawed. But it was on the basis of this type of statistical model that Shiendlin reached her conclusion that stop activity in New York is driven by race, not crime. Now, the stop rates in New York are in fact consonant with criminal activity. The black population, as I said, is 23% of the city's population in New York, but blacks commit 66% of all violent crime, 70% of all robberies, and 80% of all shootings. They make up 53% of all stops. Whites, at about 35% of the population, commit 5% of all violent crime, 5% of all robberies, and less than 2% of all shootings. They make up 9% of all stops. Shiendlin, however, does think that policing should match population ratios. Curiously and inexplicably, however, she doesn't believe that policing should match gender ratios. In New York City, the NYPD, about 91% of their stops are males, matching, again, criminal activity. Even though, again, black males are about 91% of all stops, they're under 50% of all population in New York. According to a Jeffrey Fagan type analysis, this would show gender profiling on the part of the police. Even though blacks, males commit about 91% of all violent crime. I'd be interested in hearing from Professor Rudovsky if he thinks that stops should be proportionate to gender, and if not, why not? I'm going to skip the Fourth Amendment issues. We can go into those maybe with a discussion period. But let me just conclude. Policing is driven overwhelmingly by crime, not race. But given the racial disparities in crime, policing inevitably is going to have a racially disparate impact. There's no question that being stopped can be infuriating and humiliating. And it's a tax that law-abiding residents of high-crime neighborhoods pay that people in low-crime neighborhoods do not pay. And that's a tragedy. And there's no question that the police should do everything they can to explain why they've made a stop, to treat people courteously and respectfully, and cops all too often fail to do that, and that is an inexcusable error. But the reason that the police are in minority neighborhoods is because they want to bring crime down. We have had the longest and steepest drop in crime of any big city. I would take a little bit of issue with Mr. MacDonald's analysis. The major crime drop in New York began with the onset of Comstat policing. It came down, he's absolutely right, in Los Angeles to the same extent because Bratton came there and bought the same kind of proactive policing. We should be spending the same amount of time discussing how to bring black crime rates down so that black youth nationally are not killed at 10 times the rate of whites and Hispanics combined as we're spending discussing policing, because everybody deserves to live free from fear and free from violence. Thank you.
Thanks, John and Heather. Good way to start. Let me put a little different perspective on the issue, and I want to talk both about New York City and actually Philadelphia, because we have very good data from Philadelphia as well, which actually supports a lot of the criticism of stop and frisk practices, both that Judge Sheindlin made, others have made in New York. In fact, we have an even more dramatic data in Philadelphia as to how stop and frisk in many respects does not work. Is unconstitutional because both under 4th and 14th Amendment analysis, and so let me focus on both. Let me first talk about New York, Floyd, the Floyd opinion, and the data that was found by Judge Sheindlin, which was undisputed given the recording of stops in New York. From 2004 to 2012, the police made 4.4 million stops. 4.4 million stops over that period of time. It rose dramatically from 2004, when they had, in that year, about 314,000 stops, to close to 700,000 stops in 2012. In 52% of those stops, there were frisks, which means what the officer said, based on his observations, was that he had good reason to think that the person was armed and dangerous. This was because of the reason for the stop, maybe a bulge, maybe a threat, maybe because the description of the crime was a violent crime, and I want to talk about that because Ms. MacDonald suggests that virtually all stop and frisk is in response to violent crime reports. Not so. In Philadelphia and New York, it's less than 10%. Most of the stops have nothing to do with violent crime. They're preemptive. They may be intended to stop violent crime, but they're not in response to reports about someone being shot, gang activity, and the like. So police in New York, in 50% or 52% of the cases, frisk people for weapons. In how many cases do they find weapons over that 8-year period? 1.5% of the cases. I'm going to comment on that later. That's basically the fault both of the Terry case itself and police discretion. What's going on here is kind of random stopping and frisking. You would not expect, if a legal standard was reasonable suspicion, and that was accurately and properly being applied, that when an officer said, I have good reason to think that person's got a gun, furtive movement, suspicion, late at night, high crime area, you would only find guns in 1.5% of the cases. In Philadelphia, it's even worse. In Philadelphia, on a random sample in 2013, we found that of 1,700 stops, 400 or 500 of them involving frisks, 3 guns were found. 0.16% of all the stops were guns found in those situations. And so we know there's a disconnect between what the police say they're doing and attempting to do and what the results actually are. In New York, Judge Sheindlin found that over that period of time, based on the police reports themselves, and this is the Fourth Amendment issue, put aside race for a minute. I actually think the Fourth Amendment issue is more serious than the race issue. I think we have a much bigger problem with a lot of improper stops that are made for no legitimate reason, obviously affect blacks and Hispanics more than whites. She found that over that period of time, based on the police documentation, accepting everything the police said was true on their police reports, and anybody in the real world knows that it's not 100% true on those police reports, that there were well over 200,000 stops in which there was simply no justification based on what the police said, and probably an equal number where it wasn't even clear, because the police have a checkoff system in New York. They check off furtive movements, high crime area, suspicious activity, and indeed in 40% of all stops during that period of time, a huge number of stops, 40% of those stops, what was it based on? Furtive movement in a high crime area. That's why people were being stopped, put up against the wall, frisked, and as Heather says, appropriately intimidated and humiliated in a way where there was no basis for the stop whatsoever. Indeed, in 36% of the cases, the police didn't even indicate what crime they thought was being committed as a basis for the stop. So I think Judge Sheindlin's findings on the Fourth Amendment issue were well supported. They were well supported not only by the analysis of the forms that the police themselves pointed out, but by the remarkably low hit rate. In New York, put aside when weapons were found, all those stops in New York resulted in 6% of those stops resulted in arrest, and 6% resulted in the summons. And a lot of those arrests and summonses were the result not of what the police observed, but of what they found out later. There was a warrant outstanding for the person. There was some struggle after the fact. And so it was even less in New York, right? This policing on reasonable suspicion was producing further police action, an arrest or a summons, in less than 10% of the cases. 90% of the people were completely innocent, had done nothing wrong, were being stopped, and that's why the numbers were so high, and I want to comment about those numbers as we go along. Let me talk about Philadelphia, just on the Fourth Amendment question as well, because we have a consent decree in Philadelphia. We didn't litigate the case. The police department here agreed that they were using stop and frisk improperly, and in fact, in Philadelphia, probably the stop and frisk capital of the country. In 2009, the Philadelphia Police Department stopped 275,000 persons in Philadelphia. We've got a population in Philadelphia of 1/5 of New York. If you put that out, we were stopping many more than the police were actually stopping in New York. We have been tracking those stops, reading them, auditing them for the past 3 years under this consent decree. In the first quarter of 2013, police department analyzed the stops, we analyzed the stops. We've got a better form. The police have to write down on the form in Philadelphia the reason for the stop. It's not a check-off box. The reason for the stop and the reason for the frisk. And so you can read that form and see, well, under Fourth Amendment standards, were they doing it properly? In Philadelphia, in the first quarter of 2013, the police department reported 37% of those stops were without legal justification. Again, accepting everything the police said was true, we looked at the same forms, we found 43%. Pretty close. Pretty close in terms of the Fourth Amendment standard. And when you translate that, numbers are always a little bit beguiling, 37%, 47%. You translate that into what the human, right, injury is. That's thousands and thousands of people being stopped without justification. I've already mentioned the hit rate was phenomenally low. You can do better at random. And in fact, I think in a lot of ways, stop and frisk practices are often random policing. It's policing by serendipity. You stop enough people, maybe you'll find some drugs, maybe you'll find some guns. Let me talk quickly about the race issue, the 14th Amendment issue. Sure, there was a battle about benchmarks in New York. The city proposed a series of benchmarks as to how you should measure possible racial bias. Jeffrey Fagan, for the plaintiffs, had a different set of benchmarks. The judge agreed with Professor Fagan. I think he actually got it right in terms of his analysis. Sure, nobody can claim that simply because the black and Hispanic population in New York is, which is about 52%, that you would expect the stop rate to be there. That's not an analysis anybody buys. You can't just compare stops to population and say, well, if blacks are being stopped higher than their number of population, there's something wrong. Professor Fagan understood that. He took into account police deployment. Sure, there are more police in minority neighborhoods. He took into effect economic factors. He took into effect crime rates, and still found disproportionate number of racial minorities being stopped. You can agree or disagree with that. The court found that to be the proper analysis as opposed to what the city proposed. And in fact, there were sub benchmarks that were significant as well. And let me just give you one of them. I talked about hit rates, and low for everybody, obviously. But it turned out, when you looked at the number of blacks, Hispanics, and whites who were stopped and weapons that were found, it turned out that the hit rate for weapon seizure for blacks and Hispanic was 8%, statistically significant, 8% lower than for whites. What does that teach us? It teaches us that the threshold for stopping whites is higher than it is for blacks and Hispanics. That was his result, that was his analysis, and the court accepted that analysis as well. I think what we find, I just have a couple more minutes, when we look at Philadelphia and New York, and what's interesting here is, fortunately, we have two major cities that keeps data. Nationwide, we know nothing about stop and frisk practices because most police departments don't keep any data. If the stop doesn't result in arrest or a summons or of some other kind of police activity. And so now, but we have some national experiments. We have Philadelphia, we have New York, we have a couple of other cities in which data is being kept. Remarkably, the analysis turns out to be similar in these places, both as to the high number of improper stops and also possible racial bias. I mentioned before that when we look at hit rate, it teaches us a lot. I think the hit rate, the very low hit rate, is a combination of two factors. Terry versus Ohio itself and then the later cases have created a legal standard which basically gives the police the right to stop. And I don't criticize the police for this, for using it. It gives them the power to stop and the right to stop based simply on innocent activity. You don't have to show anything that the person was doing was criminal. You can string along a little bit about innocent activity in a high crime neighborhood, late at night, looking a little nervous, right? That gives you the right to stop, according to the police. So when you combine that with police discretion, there's no surprise that we're finding 1%, 2% gun seizures, 5% arrest rates, very, very low threshold. And finally, let me end here, and we'll pick up some more. There has been the argument made that stop and frisk in New York and Philadelphia drives the crime rate down. There's a direct correlation. The more you stop and frisk, the more crime you can suppress. I have no doubt that stop and frisk plays an important part in police practices. Judge Sheindlin didn't say no more stop and frisk. It wasn't like San Diego, stop it in some district. Just do it the right way. Let me show you a chart. I don't have it up here. New York City. In 2011, I mentioned, they had close to 700,000 stops, okay? By 2013, mainly because of the Floyd litigation and the political dispute in New York, the number of stops had dropped from 700,000 to 300,000, over a 50% drop in that 2-year period. The homicide rate dropped from 500 in 2011 to close to 300 projected for 2013. And so, now I'm not saying those statistics prove that stop and frisk doesn't work. Stop and frisk can work. What you have here is 400,000 fewer stops, 200,000 fewer murders. Those 400,000 stops, I suspect, right, which were made the year before, were made for no reason whatsoever. They were mainly racial minorities. There's a diminishing return. And I think the city, the police department realized that. I'm surprised they didn't take credit for that. They were so defensive in saying this is the only answer to crime in New York. They should have taken credit for that. They should have said, we're pulling back. We understand we've overreached. They did overreach. And that kind of overreaching, I think in New York, interesting to me, not only led to a legal opinion, which was adverse to the city of New York, at least as an entity, but politically, I think in New York, people realize also the police have overreached and there needs to be some kind of adjustment.
I'm going to give a minute or a minute and a half to Heather here.
Okay. On the weapons hit rate, the overall weapons hit rate.
I want to go to the mic.
Oh, I'm sorry. Guns are actually found on blacks at 2 times the rate as whites are found, as they're found on whites. And I'm just curious, truly it is not a rhetorical question, on the Fourth Amendment issue, what you think a proper arrest and summons rate should be. We always hear that 6% is too low for arrests and 6% for summons. What should it be under a reasonable suspicion standard? It is not the case that just because somebody is not arrested or summons that he was, as Shiendlin says, and also Professor Rudovsky, completely innocent. If there's been a series of sex assault attacks in a public housing project, in elevators and stairwells, for instance, and the police see somebody loitering in the lobby who has let an elevator go by for several rounds when a male enters, and when a female enters, he comes in. And the police make a stop there and question him. That's not going to lead to an arrest if that has averted a crime, but that may well have averted a crime. So there's lots of stops that are made if somebody's been trying car doors on a street that has had car thefts, and the police make a stop there. Again, there's no probable cause to make an arrest for car theft, but that stop could well have averted a crime. So I'd like to know what you think that the hit rate should be, and also I take issue with the idea that everybody who's not stopped and arrested is innocent. Some are, no question. There is no question that innocent people have been stopped, and many of them are very resentful. Some are not, however. I have talked to a lot of people in the inner city who say, look, between being shot and stopped, it's better to be stopped, however annoying and disparate that activity is.
Why don't we just open it up to questions here and just continue the discussion through questions. Yeah.
Okay. Even if we give absolute credence to Judge Sheindlin's statistical analysis, less than 4.5% of the stops were considered, in her mind, to be unconstitutional over the 8-year period. So my question is, why is a complete policy reform the proper remedy to that, as opposed to maybe compensating the relatively small number of victims of constitutional violations, which would then deter the police department from making these constitutional violations, perhaps because of financial and political reasons? But anyway.
Well, let me use that to answer Heather's question as well. What's the appropriate benchmark for Fourth Amendment standards, right? If we talk about reasonable suspicion, what do we think we should be finding? I think we should be finding when reasonable suspicion, and remember, frisks are being made only when there's reasonable suspicion there's a weapon. So I'm not even talking about 5 or 10% there. I'm talking about 1 or 1.5%. Police are saying, I've seen objectively behavior which I think that person has a gun, and it's only 1 of the 100 cases where you find a gun. Either they're not telling the truth, or the legal standard is so low that we shouldn't live with that legal standard. What should it be in terms of arrests? I can't give you a magic number, 15%, 20%, 25%. 5% is not right in my mind, and I don't think that's what the court thought when they developed the reasonable suspicion standard. Compare that to probable cause, which is not also a very high standard, but where at least the police have to be able to identify some criminal activity. Search warrants, we get 80% results of finding contraband. Arrests are generally upheld 50%, 60% of the time. There's not a huge difference between probable cause and reasonable suspicion. The difference is reasonable suspicion can be based on completely innocent conduct.
Just to pick up on what this gentleman suggested, there's two sort of sets of numbers here. There's the objectively undisputed data, which Professor Rudovsky rightly points to, which is that 6% of all stops yield an arrest and 6% lead in a summons. As this gentleman points out, having obviously closely read the Shiendlin opinion and Fagan's analysis, he did an analysis based on something called a UF-250, which is the little forms that were developed in conjunction with the Center for Constitutional Rights based on their previous class action lawsuit against the NYPD that checks off categories of the grounds for the stops. Fagan came up with a methodology for classifying the stop based not on whether it resulted in an arrest or summons, but based on the boxes that were checked on the UF-250, which is really not adequate to determining whether the stop was constitutional or not, because it's a totality of circumstances that does, a set of check-marked boxes does not convey what the officer saw in the neighborhood, what he knew about crime patterns. Nevertheless, based on an inadequate methodology, which was just to say, okay, I like it, if the UF-250 has checked off, drugs in the area, known drug suspect, that I like. I don't like furtive movements for some reason, and I don't know, furtive movements in high crime, that's going to be a lot of what police know as gang activity is going to come under that description. Nevertheless, Fagan doesn't like furtive movements in high crime matters neither does Shiendlin. Based on that methodology, only 6% of stops were presumptively a violation of the Fourth Amendment. Nearly 90%, according to Fagan, were presumptively valid. Shiendlin never explained where she comes up with the number that then represents a constitutional violation of deliberate indifference. So, I mean, maybe you could explain why is a 6% presumptive invalid stop show that the police department is deliberately indifferent to a known pattern of constitutional violations.
Let me make 2 points. Number one, I agree the New York form is an inadequate form. The Philadelphia form is much better. The police here are required to write down what's your reason for stopping, what's your reason for frisking. When we do that, we're getting what we see in Philadelphia, and I doubt that the policing in Philadelphia is different from the policing in New York. We're getting between us and the police department 40% improper stops. What Judge Sheindlin found in New York was that Jeffrey Fagan gave very, very conservative estimates. He said it's clear that 4 or 5% or whatever the numbers were clearly stops without any reasonable suspicion whatsoever. He said there was another category where they had reasonable suspicion based on what the officer checked off. And on the New York form, the officer can also write. He can add information as to whether it's gang activity or something else, so they can do that. And then there was a whole indeterminate area where you just couldn't tell from the form whether there was grounds or not, and Judge Shiendlin looked at some other factors. For example, the one I mentioned, 40% of the forms, furtive movement and a high crime area. What is that? In individual cases, I agree. The officer could probably come to court and explain, well, that was shorthand, and I thought it was gang activity, and I saw other things, and that's fine. But you know, in a case like this, you can't, as she said, we can't litigate 4.4 million stops, and so we do the best we can with what the police department itself used as a stop form. Nobody required them to use that form. They could have had a better form, and hopefully in the future they will.
Any other questions? Yeah. Oh, I'm sorry.
I just wanted to weigh in with one thing. I think there's a bit of a false dichotomy that you can't reduce crime without stopping lots of people. We have plenty of good research on hotspots experiments showing if you put extra police in a high crime area, and this is what New York is doing in impact zones. We don't have good evidence that you need to actually stop lots of people. So I'm completely comfortable in thinking that the crime rate will continue to be low in New York, even if they're not stopping lots and lots and lots of people, simply by the fact that they're deploying extra officers to the right places, just high crime areas where they should be. So I'm actually not as concerned as Heather is and others about this somehow leading to a crime surge in New York. I don't think we have good evidence to suggest that you actually have to stop so many people and at least whatever the right number is, violate some share of people's rights to get the crime rate low. I just think it's not a false dichotomy.
But hotspot policing, I mean, it's true, there's definitely a positive impact from just sheer police presence, and I agree with Professor MacDonald there. But what the officers are doing in impact zones, and this is a program that Police Commissioner Ray Kelly developed, that taking new rookie cops rather than distributing them pro rata across the city to every precinct, where once they're there you can't pull them out because everybody wants their cops. He takes the recent graduating class and bunches them in very carefully statistically determined high crime zones of the city. East New York gets them all the time, the South Bronx, Central Brooklyn, and they walk foot posts, but they also make stops. And I mean, this is another of the memes that is out there saying that, well, the problem is these impact zone rookies are not adequately trained in making stops. So they are making stops. And I mean, I agree with Professor Rudovsky. There is a diminishing returns aspect, and there's no question that Commissioner Kelly is pressing harder and harder to bring crime down, because the NYPD has been on top of its game for so long now that it gets harder and harder to bring crime down, and yet there's still killings like 14-year-old Ms. Robinson that have to be stopped. So I think that there's no question that stops have caused people to start keeping their guns at home. And we have it on the record from criminals. Recently we had a wiretap on a big gun running operation. A guy said, I can't come up to New York, I can't bring my guns up there because they do stops in Brownsville. perps are saying we're keeping them in communal spots under mailboxes. That's not ideal. You don't want them to have it all, but it's better than having it on their person where they can immediately react in a high emotion situation. So, I think that there is a risk that if that pressure comes off, people will go back to carrying guns again the way they were in the early 90s.
As just to exercise moderated privilege, I just wanted to ask about this idea of deterring people. There was someone at Morton who wrote a paper a few years back, I think his name was Persico, who said we can't distinguish between, in a low success rate for stops, between a deterrent effect that's powerful, that people are just not bringing their guns with them, so we are going to get a low hit rate, versus we're just violating people's rights. So I wonder if you could just address whether this might be a deterrent.
Well, I don't doubt, as the airport searches are, I think people don't bring guns, although I'm surprised at how many people still bring guns to the airports. If they forget it or not, but human behavior being what it is. I don't doubt that it has a deterrent effect. All policing has a deterrent effect. The hotspot policing, the number of police on the street. Prosecutions have an impact on crime. We all agree on that. There are multi-factor causes here. But I don't think anybody here would suggest that we use unconstitutional means to get that deterrence. I mean, we could say, for example, 90% of the people convicted of robbery are African Americans. So let's double their sentences. If you're African American and you're convicted of robbery, we'll give you 20 years. If you're white, we'll give you 10 years. We'll get some more deterrence out of that, for sure, but nobody here would agree with that. Nobody would agree that the police should be let loose to stop people for no reason at all, and search their houses for no reason. We could suppress more crime that way. There's no question about that. So I think you're right, and I agree with you. There is some deterrence we get from this, and I think we agree on this. We don't need in New York 700,000 stops. We don't need in Philadelphia 270,000 stops, and indeed, it's been reduced in Philadelphia. It's now down to about 200,000, and the crime rate came down in the last 2 years, notwithstanding fewer stops. Better stops, for sure. Stops with good reason, frisk with good reason, nobody's disputing ought to be done. But I think police departments in New York and Philadelphia became so enamored with the notion that we can get guns off the street, we can deter people by stopping so many people. They've gotten a backlash. Some people like it. They feel safer. I suspect a majority of people, is in my sense, both in New York and Philadelphia now, say it's been overdone. And you alienate people also. Now, police have to rely on people in the community. Certainly the people I've talked to here, the clients we've had in our class action, a lot of them say, I won't give information to the police because I know what's going to happen with that information. My friends and my neighbors and my sons are going to be stopped. And you risk that kind of loss as well.
Well, there's not, the anti-snitching ethic is everywhere. So
for sure.
That's certainly, Chicago, they say I could solve every crime if people cooperated, and Chicago was held up by Tracy Mears and Jeff Fagan as a model that we could emulate for policing. So I don't think that's unique to New York.
Mark, did you have a question?
This is for Professor Rudovsky.
Speak up, though.
This is for
We can't
Professor
really hear you.
Rudovsky. So you expressed some skepticism of Terry versus Ohio. And so, that, regardless of whether or not that's a good case, is still, as far as I know, binding precedent. So, to what, how is the stop and frisk policies in New York and Philadelphia worse than the standard, not meet the standard in Terry versus Ohio, rather than the standard?
I expressed skepticism about
Terry versus Ohio.
Right, okay, yeah. So, Terry, I think, actually was right. There was a guy, it was a case in a store. There was evidence it was a robbery, not yet. Probably a good case in which he thought possible violent crime, reason to stop him, reason to frisk him. As you know, those who take criminal procedure over 45 years, the court has expanded what was a fairly narrow doctrine aimed at violent crime and stops for violent crime short of probable cause into the right of police or the power of police to stop you for the most trivial reason, whatever they think this crime might be, from truancy to murder, but mainly for very minor crimes. And they've continually, the Supreme Court, relaxed the standards, right? And so, and they've made these kind of what we say common sense, what the court repeatedly says in stop and frisk cases, it's common sense to think if the police see a young black guy in a black neighborhood and that guy runs from the police, he's up to no good. Well, we now have good empirical data, right? that doesn't translate. It's a very poor predictor of crime. What we're finding from this data is that both the Terry standards and the police discretion don't match. What we find from the data is that all the assumptions we've made without any empirical basis whatsoever aren't always true. Furtive movements, suspicious conduct, high crime area, those kinds of disturbances don't lead to weapons, they don't lead to drugs, they don't lead to proper arrests. And so I think we really have to, and this is not the police fault, they're going to use whatever powers the court gives them. I think the court has been very lax, assuming all this, right, is going to be done properly by the police, and I think you need a tightening of those standards.
But again, I don't know of any police department, much less court, that would say being black and running from the police, absent a lot more, is grounds for stop. But in any case, the question is...
The Supreme Court in Warlow.
The question is, but what is...
There it was.
With furtive movements, I mean, what do you think the proper arrest and summons rate should be then? If you're saying we know that it doesn't work, you're assuming again that without an arrest that was not a proper stop, or you're also assuming clearly that there was not a crime underway. There may have been a crime underway, and the purpose is not, it's proactive, it's to stop crime and not to make arrests after the fact. That is the essence of New York policing.
I agree with you. Just because an arrest wasn't made, you didn't find something that was stopped, still could have been absolutely permissible. I agree with you. You've got information, you got to look out for somebody, you don't find anything, well, you have the wrong person. You see somebody, and I think it's perfectly acceptable, you see someone try to open the doors of 3 stray cars, that's reasonable suspicion. I can stop that person. Are you going to find evidence of a crime? Maybe not. It's still a good stop. We count it as a good stop in Philadelphia. We're not talking about those cases. We're talking about cases literally where the police say, and the Supreme Court has said, high crime area, young black man runs from the police, that's reasonable suspicion. That's Supreme Court doctrine. And so you can see why police stop in that kind of situation. What does a furtive movement mean? I mean, we don't know. What's the percentage? I would think reasonable suspicion, properly defined, means at least in 15–20% of the cases, you're going to find some evidence of criminal conduct. And 1% for guns and 5% for arrests, I think that kind of reveals the problem in the doctrine.
I'm just weighing one point is, if you think about the number of stops too, there's, if you actually, it's not just the number, it's not just relative to the population, but it's also in specific high crime areas. There is a huge, the number is pretty outstanding. In New York, in the high crime neighborhoods, it's probably about 90% of African American men between 18 and 24 have been stopped by the police in the last year and a half. That, I mean, if you think about that, that would be like if 90% of this room had been stopped by the police. And you say, well, yeah, this is Penn Law. But even so, even if Penn Law was in the worst neighborhood in Philadelphia, and 5% of you were actively engaged as career criminals, should 90% of the room be subjected to what's being generated by 5% of the population? I mean, this is the problem with kind of opening the floodgates and letting police stop as many people as they feel like they need to. It's ignoring the fact that most crime, even high crime neighborhoods, is committed by a fraction of the population at a very small micro level. Like 3% of the addresses are going to generate 50% of the crime. 6 to 10% of the population is going to generate 70% of the street crime. So should you subject 90% of people in that same age demographic to stops? I mean, this is why there's public backlash.
How did you? I've not heard that number before. Is that? Are you just doing a simple division, or because what you have is often multiple stops of known gang members, and what Weisberg has found is that stop and frisk in New York is inextricably tied to hotspots. It is not.
Oh, yeah, definitely
It is
it's
not
tied to
across.
hotspots.
So,
But still,
does
I mean-
are 90% of the population in a precinct moving through those hotspots, or are they stopping the same small number of people
Well,
again and again that are hanging out on
That's
the
a good
corner?
question. Even if you adjust for multiple stops of the same people, maybe the number comes down to, by a third. But still, so if it's 60% of the room, you can do hotspot policing without stopping everyone. I mean, you can use a higher threshold under terror, and you can reduce crime. You can get guns off of people, but you don't have to stop every young black guy walking down the street in a high crime neighborhood. I mean,
No, and I don't think they should be.
And that's
We agree on that. We
Yeah.
agree on that.
Can I
And
just
think
clarify
that
those
they're not.
figures? You said 5% of the population is responsible for.
6 to 10% is
Okay.
generally responsible. All the kind of cohort studies find for about anywhere up to 70% of serious crime.
Because I've seen statistics that in these very heavily African American neighborhoods that something like 30 or 40% of the men are under criminal supervision.
Yeah, but usually for
So how does that-
low level offenses, not possession, for a simple assault, for maybe a theft, not for serious, consistent crime.
And if we had as many police in the dorms and University of Pennsylvania as we did in North Philadelphia, we'd have a lot of white people in marijuana possession. Right? I mean, there are those numbers, but there's also kind of
So I
disproportionality.
mean, what you're doing makes sense. You put the police right where the high crime areas. I just think that there's been a balance somehow that's gotten shifted to thinking that you have to do all those stops. And we don't have good evidence that you need to do all those extra stops.
Police are put in New York to where community asks for them.
No, I understand.
If dorms were asking for police, they'd be here, but the reason they're in Brownsville is because that's where
Yeah,
elderly
in Lawrenceville.
residents are asking.
And I agree that, I think that's where they ought to go. I'm just pointing out that the reason we have a lot of young black men under supervision is not for violent crime, it's for drugs and the war on drugs.
I was just wondering, obviously our panel here doesn't look much like folks that were stopped off at stops. Can you comment on, A, whether you've been subjected to the indignity of having to put your hands up on a wall and be frisked by the police, and B, whether you think that race and or gender has anything to do with the fact that you have them there? Maybe starting with MacDonald.
No, I've not been stopped and frisked, and I do not have shootings in my neighborhood. If there were shootings in my neighborhood, I can guarantee you that the community members there would be saying, we want police activity here.
Do you think that, for you, would that be a worthwhile sacrifice to have to put your hands up on the wall, having never committed a shooting yourself, living a life as a law-abiding citizen?
If it was a question of fearing that I or my children or my family members would be facing the risk of homicide that we had in New York City, yes, I would think that was a valid trade-off. As frustrating as it would be, I would expect to be treated respectfully. But if that was the question, yes. And there's many people in New York that agree with me.
Let me just say that point about respect, I think that's something we agree on 100%. I suspect that we wouldn't have to be having this debate today if the police, when they stop people and they find nothing and they can't do anything further, would either do one of two things. Apologize, which police find themselves incapable of doing ever, or at least explaining why they made the stop. I stopped you because we got a call on the police radio, there was this description, you're on your way. But the anger and the humiliation of being stopped, sometimes racial epithets, right? Nothing's found, on your way home. Why was I stopped? Buddy, you're going to be arrested if you ask me another question, right? I mean, that's the tone. And the police department seemed incapable. I mean, if in 90% of the cases they gave an explanation, you wouldn't have this reaction. People would say, they might not be happy, but they would accept it. And I think that part, Heather and I agree on completely. If you change that mode, you'll have less tension
That
about
was-
this procedure.
And I also agree with the proposal in New York City out of the City Council that officers be required to give their names and, badge numbers when they make a stop, because they're public officials, they owe a duty of transparency to the public, so I would support that reform as well.
And I would argue that the community members do want more police there. That's indisputable. But they want a different form of policing. They don't want shakedown. They want effective, aggressive policing, but not random stops. I think that, and that's pretty clear if you look at disparities in people's perceptions of the police.
And I would dispute that they're random and fluid.
Thank you. While it's heartening to see that FedSoc has developed an honest and genuine concern for communities of color since last spring's death penalty event, given that fewer than 1 of 1,000 stops in New York City resulted in finding a gun, is it possible that the nominal benefit of stop and frisk from a law enforcement standpoint is outweighed by raising an entire generation of children in an environment where they learn that the police are more likely to antagonize, humiliate, and harass them without cause than to help them?
Is that a question?
Yeah, I mean, as MacDonald, you spoke about stop snitching. Why on earth would someone go to the police when the police are there to harass your families and your friends, and you grow up in this environment where you learn that the police are not there to help you, they are there to bother you and to sort of impede you as you go about your daily life all the time?
Well, I suggest...
Here to your neighbor.
I invite you to attend a police community meeting. I'll take you to one if you want to go in the 40th or 41st Precinct, 23rd, 28th, 33rd in Harlem. What you're going to hear is we want more activity. We do not want people hanging out on the corners. I'm scared to go into my lobby. I'm scared to go out and get food. And I see the cops as the protection between me and anarchy. And I would also encourage you to read what New York was like in 1990, 1992, 93, when entire thoroughfares were controlled by drug lords. And children were sleeping in bathtubs. Their mothers put them there because the risk of stray gunfire was so high. This was not imposed on them by the police. This was their voluntary choice. And